Oh yay, oh yay, oh yay. This Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court. Please be seated.
Good morning. Welcome to the April Nashville docket of the Tennessee Supreme Court. We want to welcome those who are watching on live stream through our YouTube channel. Also want to take a moment just to welcome Justice Campbell with us. Justice Sarah Campbell is our newest member. This is her first time to sit in Nashville. She's already a valuable member of the team, and we're glad to have her. Welcome, Justice Campbell. All right, we have 5 cases for argument today, 3 cases this morning and 2 this afternoon. Each side will have 30 minutes. If appellant wishes to reserve rebuttal time, please let us know that when you come up to argue your case. Mr. Hivner, you may call our first case.
Beverly Garner versus St. Thomas Midtown Hospital.
Good morning.
Good morning.
Morning.
I would like to reserve 5 minutes for rebuttal. May it please the court. I'm Pat Sheegan. My local bar is Montgomery, Alabama, and it is my privilege to be before your honors on behalf of the appellant, St. Thomas Midtown. With all due respect, we say that the Court of Civil Appeals erred in this case when it reversed the trial court's order granting summary judgment in favor of St. Thomas Midtown based on a finding that there was a conflict between the common law principles laid out by this court in the Absher decision and the pre-suit notice provisions of the Healthcare Liability Act. We say that the plain language of the Healthcare Liability Act should apply in this case, as well as the Absher holding, and that they are not inconsistent. And when those two things are put together, and when those things are applied together, the correct conclusion is the conclusion that the trial court, Judge Binkley, came to, which was to grant summary judgment in favor of St. Thomas Midtown, because when suit was filed against St. Thomas Midtown, the statute of limitations had run as to the timing for the claims as to the anesthesia providers, and therefore the claim as to the anesthesia providers were barred by operation of law under Absher, and that was the basis for the court's ruling in the trial court. Now, the plaintiff's claim in this case arose on May 8, 2016. She underwent surgery at St. Thomas Midtown, and she encountered a complication of anesthesia with the endotracheal intubation that was performed by the anesthesia providers who were not employed by St. Thomas Midtown. They were independent contractors. There was no claim made in this case. There was no evidence presented in this case that there was any inability or difficulty identifying those anesthesia providers.
And is there yes. Any evidence to suggest that the plaintiff in this case ever intended to sue the agents?
No, Your Justice. There is no evidence that there was any intent to sue, and in fact, I believe in the very last brief filed by the plaintiff, they stated that this was their one shot. They were taking a frontal shot against St. Thomas Midtown for the actions of these independent contractors.
And isn't it within the right to do that?
Well, under Absher, the plaintiff does, at common law, the plaintiff does have the right to pursue the principal, the agent, or both in a case of this nature. However, Absher recognized that there are 4 instances where the plaintiff cannot do that, where the plaintiff cannot proceed against the principal based on the actions of the agent. And in this case, the 4th instance that this court set out in the Absher case is what applies, where when the lawsuit is first filed, or when the the attempt to make a claim for vicarious liability is first made against the principal, the claim against the agent is already barred by operation of law. And so in this case, as the trial court held, the claim against the anesthesia providers was already barred by operation of law, and therefore under Absher, the plaintiff could not proceed against the principal, St. Thomas Midtown.
Counsel, wasn't Absher just decided under a different factual scenario? The Healthcare Liability Act was not enacted. Pre-suit notice was barely enacted, but not an issue in the facts in Absher. I mean, isn't it just distinguishable? We take it. We don't just take the broad pronouncement in Absher without understanding it in the context of its factual scenario, don't we?
I think the court takes into consideration everything, the facts of the case, the law as it existed, and the law as it exists at the time the ruling was made.
Well, doesn't the factual scenario in Absher counsel against what applying it in a factual scenario today that involves both pre-suit notice and the Healthcare Liability Act provisions, and specifically the 120-day extension?
We do not believe that it does, Your Honor, because first,
why should we ignore those facts is what I would like to hear you address.
Why should we ignore
The difference in the factual scenario in Absher versus the factual scenario we have here?
And when you say factual scenario, you're referring to the fact that we have the
Pre-suit notice and the Healthcare Liability Act
Yes, right.
extension of the limitations period.
Well, first of all, when Absher was decided in 2010, as you alluded to, the pre-suit notice, while it was not at issue in Absher, it was the law. And if the court,
Why is that significant if it was not involved in the facts in Absher?
well, it would be something that the court was aware of, and if that was such a significant finding, one might expect that would be something that the court would have pointed out. I think there are times where the court has pointed out that there'd be a different outcome because the law has changed.
Perhaps it was so clear that the Healthcare Liability Act would not apply in Absher that it was no need to raise it, since the cause of action in Absher accrued in 2001. That was before the adoption of the 120-day extension and pre-suit notice and all that came with it.
I understand
Right.
that, Your Honor. I think that in 2010, we did have pre-suit notice, and it was a very clear statement by the court that if a claim against an agent was barred by operation of law at the time suit was filed, then the claims could not proceed against the principal.
Well, sometimes when courts make statements in these cases, we can't think of every possible scenario that someone may look at. And since the Healthcare Liability Act already required pre-suit notice, but it didn't arise in Absher because it accrued in 2001, why would the court even address that in Absher?
Your Honor, that's a great question, and I don't know. I don't know why the court would not have. I don't know that the court necessarily considered that.
Well, it would have been dicta at that point, wouldn't it? If they had even addressed it.
It would have been. Yes, Your Honor.
I mean, it might have been a footnote, which would have been dicta, which wouldn't have really helped anybody at any point. But under your theory, a plaintiff who sues, say, a hospital under vicarious liability without suing the agents really cannot take advantage of the 120-day. They have to give pre-suit notice, but they can't take advantage of the 120-day extension. So effectively, their statute of limitations is shortened.
Well, Your Honor, I would disagree with that in that the plaintiff really has two options in this case. The plaintiff did take the position that what we were arguing would shorten the statute of limitations. However, there would be no shortening of the statute of limitations. The statute of limitations is 1 year. and it was 1 year from the cause of action accruing. In this case, the plaintiff had two options at least that would have complied with both absure and the pre-suit notice requirements. First, if the plaintiff only wanted to give pre-suit notice to St. Thomas Midtown and did not want to give pre-suit notice to these independent contractors, the plaintiff could have given pre-suit notice 60 days before the statute ran and then filed suit at 1 year. And that...
And not get the benefit of the extension?
You're correct. Yes, Your Honor. That would not have allowed the benefit of the extension, but that would not do what the plain language of Section 121C says, which is that it would not shorten the statute of limitations. It would not extend the statute of limitations or allow the plaintiff to have an extension of the statute of limitations, but
doesn't it defeat the purpose of the extension? I mean, the legislature did not grant the 120-day extension just out of the goodness of their hearts. They added significant requirements on the plaintiff before filing suit.
Right.
So the plaintiff gets the worst of both parts of that bargain. Doesn't that frustrate the legislature's intent?
I don't think so, Your Honor, and I think, in fact, what the plaintiff did in this case does exactly what you say, which is to frustrate the legislature's intent. The whole purpose of the pre-suit notice framework, as the court stated in the Foster versus Childs case, was to allow the defendant an opportunity to investigate and consider settlement of claims during the pre-suit period. And in this case, where the plaintiff has sued an where the plaintiff has sued the hospital based solely on the actions of independent contractors, the whole purpose of the framework has been frustrated, because in this case, the plaintiff is suing the hospital based on the actions of providers over which the hospital has no control, and the hospital's attorneys cannot interview to discuss the care or the statements made in the pre-suit notice.
But counsel, let me just interrupt you there for a second. I mean, if the only way that the goal that you're identifying would be accomplished is if the plaintiff in this case had actually given pre-suit notice to the agents. Isn't that right? Your brief argues that you were hampered from investigating and getting information from the agents because you didn't get pre-suit notice. There was no authorization. But the only way that would have occurred would be if the plaintiff had actually given pre-suit notice to the agents. Isn't that right?
That is correct. Or if the hospital is being sued based on the actions of its employees, the hospital would still have access to its employees. That's why this is a...
But how would the first option you identify, which would be, the plaintiff providing pre-suit notice 60 days in advance of the expiration of the statute of limitations, how would that help the situation that you identify, which is that, your client is unable to fully investigate the claim? So option one, the agents still don't get pre-suit notice. How does that solve the problem that you identify?
Well, in that option, you're right, Your Honor. The hospital still would not be able to interview but in that situation, the statute of limitations would not be extended, and you would not have a situation which is also inconsistent with the language of the statute, where the statute has been extended for 120 days as to an anesthesia provider or these independent contractors who never received pre-suit notice, which again, that would be inconsistent with the court's holding in the Runyon's case that says that the statute of limitations will not be extended except for those providers who receive pre-suit notice. And so,
but you agree, don't you, that a plaintiff doesn't have to sue the agents? A plaintiff, just setting aside the pre-suit notice requirements, all of that, just in general, under the common law, a plaintiff doesn't have to sue the agents. A plaintiff may choose. A plaintiff may sue the principal under a theory of vicarious liability and not sue the agents at all. Is that correct?
Yes, as long as the claim as to the agent is not already barred by operation of law. And that's where we say that absure has to come in, because if there's not a conflict, and we say there's not a conflict, we say they both can apply together, both absure and the pre-suit notice requirements. And if they apply together, absure applies, and if the claim against the agent is procedurally barred when the suit is filed against the principal, then the suit against the principal cannot go forward. And that's why we say there are the two options. The plaintiff could choose to do it with 60 days before suit, giving the pre-suit notice and then filing suit at 1 year, which is the statute of limitations under the law, or the plaintiff could give pre-suit notice to both the hospital and the anesthesia providers, and that would give the plaintiff the benefit of the 120-day extension of the statute of limitations.
But why would a plaintiff do that? I mean, why would a plaintiff who has no intention to sue the agents and is not obligated to sue the agents under the common law, why would that plaintiff provide pre-suit notice when pre-suit notice is only required when the plaintiff intends to sue that party?
Well, in this case, we have anesthesia providers who, an anesthesiologist cannot even be employed by a hospital under Tennessee law.
But they can be apparent agents, correct? And that's the theory here, that these providers were the hospital's apparent agents. And going back to your statement that this creates a hardship on the hospital, hospital had all the medical records. At the time you got pre-suit notice, you had access to all the hospital's records, your own records, which included the anesthesia provider's records. So how were you harmed, or how were you unable to evaluate settlement or to carry out the purpose of the Health Care Liability Act when you already had access to all the records?
Well, the records were available, but in evaluating a settlement in a case like this, where you're dealing with the providers who, I mean, this is...
And what kept you from talking with those providers?
I'm sorry?
What kept the hospital from consulting and discussing this with those providers?
Tennessee law does not allow the hospital to its attorneys to talk to non-employed providers based on confidentiality. In fact, in this case, we had to file a qualified protective order through the discovery process, which was filed in the case. And that's ultimately how we learned, once through the discovery process, that the only claims the plaintiff was pursuing were based on the actions of these independent contractor anesthesia providers.
But you're in exactly that same situation as Justice Campbell pointed out with the first proposed solution that you have to reconcile all of this. If the plaintiff is required to file suit before expiration of the original 1-year statute of limitations, you're in exactly the same situation. So that cannot be the point of this. All of this, the clunkiness of your proposed solution, either requiring the plaintiff to sue earlier than would otherwise be required under the Health Care Liability Act, or making the plaintiff sue agents or give pre-suit notice to agents he has no intent of suing. All of that circles back to why should we apply the holding in Absher when it was such a dramatically different factual scenario? I still am not quite understanding your basic answer to that question.
And I think ultimately the answer, the biggest answer to that is in the situation where you have, and I understand what you and Justice Campbell both have stated about we'd be in the same position, but it's still a very unfair situation for the hospital where they have been sued for an independent contractor, where even if, in this instance, we had the medical records, but we cannot discuss this with them.
That's not what Absher was aimed at, was it? Absher was aimed more at the kind of situation where a plaintiff makes a choice not to sue the agents. Oops, and finds that there's a problem with the direct liability claim against the hospital, and then falls back and says, well, I'm just going to use vicarious liability. That's what Absher was aimed at. And that does not seem to be presented here at all.
I mean, it is a different factual situation, but the court did not. I mean, the plaintiff argued that that it only applied where we had a situation with a mistaken or a late attempt to amend, but the Absher court didn't limit its ruling. It said that if there is a suit against a principal, and when the vicarious liability claim is first made, if it's barred by operation of law, then it's barred, and you can't proceed against the principal. We are operating on that. We are operating on that as the Court of Civil Appeals held in the. I know it's not for citation, but the Taylor versus Miriam's Promise case is what, you know, when we see that, that's the same reasoning, and so the Court of Appeals decision in this case is directly in conflict with that decision, and we think that Absher is good law, and we believe that the plaintiff can, in these circumstances, the plaintiff can comply with both the pre-suit notice requirements and the ruling in Absher. And in an even different situation that could occur is where the hospital is sued for provide independent contractors whose records are not in the hospital records, and it's even a further step away.
We counsel respectfully, fairness is not the issue here, is it? What we have to do is construe the statute and look as to whether Absher applies. Fairness has nothing to do with this, honestly, does it not?
Your Honor, I think that the court ultimately should follow the law, and if the law results in a situation that's unfortunate for a party, that's ultimately too bad. But
and that's our job, is to follow the law here.
It is yes, Your Honor, and we say that in fact that to follow the law in this case, the court should look to unless there is a direct conflict, the court should apply the common law and the statutory language, and in this case, we think that they're not inconsistent and that they do apply together, and the ultimate decision in Absher does apply here, and that the plaintiff has other routes. The plaintiff has multiple other routes in this situation. The plaintiff could have done what the plaintiff in Bidwell did. If there was some difficulty in identifying the provider, the plaintiff could have pursued the 90-day grace period to amend the complaint and try to bring in the anesthesia.
I mean, you seem to be going back to this idea that the plaintiff was somehow obligated to sue the agents. And I'm troubled by that because it's so clear under the common law that there is no obligation to sue the agents, that a plaintiff is entitled to choose their defendant and, pursue a vicarious liability theory against the principal instead of suing the agents. And this really goes to your option too. I don't really understand this option. Are you proposing that pre-suit notice be provided to the agents just so that the principal can get information from the agents, but that there's no obligation for the plaintiff to actually sue the agents?
Right. Yes, Your Honor. So to the first part of your question, yes, Absher absolutely stands for the proposition that the plaintiff has the option under the common law when pursuing a vicarious liability claim to sue the principal, the agent, or both. But the court also provided an exception to that general rule, which we're operating under, where we say that the claim against the agent has been procedurally barred.
Let me read you just an excerpt from Absher. So this is where the court is talking about this fourth limitation on which you're relying, and the court explains the reasons for that limitation. And quoting here, plaintiffs, so this This limitation reflects one of the traditional policy reasons for refusing to permit a plaintiff to pursue a vicarious liability claim against a principal. Plaintiffs should not be permitted to engage in an encircling movement against the principal when they cannot pursue a frontal attack on the agent. In what way is the plaintiff's claim in this case an encircling movement against the principal? Has there been any doubt at any point in this case that the plaintiff intended to bring vicarious liability claims against the principal, against your client?
No, we would say the encircling movement would be coming against the principal when the claim against the agent has been procedurally barred by operation of law, because the plaintiff has relied on the 120 days to extend the statute of limitations as to these independent contractors, but gave no pre-suit notice to those independent contractors.
But isn't that the bottom line here too? Is the question is, if the plaintiff wants to take advantage of the extended statute of limitations, do they have to provide pre-suit notice to the agents as well as that? And that's the bottom line here, is it not? It's not a question of providing pre-suit notice so your client can talk to the independent contractors. I think we're getting off on the your argument is on the fairness issue, and we need to have a statutory construction and application of common law here.
Right, and we would say that yes, there were two options: either to give the pre-suit notice only to the hospital and proceed within 60 days before trial, and to then file suit at 60 days at 1 year, or to provide the pre-suit notice to the anesthesia providers if the plaintiff wanted to take advantage of the 120 days extension. And the only basis for the statements about the unfairness is the fact that the framework set up by the Court of Appeals decision totally frustrates the whole purpose, we believe, of the pre-suit notice provisions, in that it does prevent the hospital from adequately investigating and being able to make reasonable settlement decisions when you have, in this case, where you have independent contractors that the law does not allow the attorneys to interview.
Mr. Sheegan, you're into your rebuttal time now.
Yes, sir.
Okay.
Thank you, Your Honors.
Good morning.
Morning.
Lavelle Glanton, Jr. I'm not sure if I was on the brief for this, arguing for Mrs. Beverly Garner. May it please the court. The issue today is...
Have you entered an appearance of counsel in the case?
Enter an
He's
appearance.
listed.
Did I enter an appearance? Yes, ma'am.
Yeah, I think you're, yeah. Okay.
Yeah.
Okay.
Listed.
All right. The issue is the plain meaning of the Healthcare Liability Act statute as it pertains to both giving notice and the requirements for the 120-day extension in filing a lawsuit. Here, Mrs. Gardner gave notice within the 1 year statute of limitations and filed a suit within the grace period of the 120-day extension for filing a lawsuit. There is no question as to whether her injury falls up under the Healthcare Liability Act. There's no question as to whether St. Thomas Hospital is a healthcare provider. The issue is whether the common law and the case in Abshore bars Mrs. Gardner from bringing a claim, though she followed the statute as it was intended. The Tennessee Code Annotated 2926-121 states that you must give 60 days notice prior to serving a defendant with a claim for malpractice. It only states that you must give those defendants which you tend to bring an action that notice. And the court has found in the past that the only requirement for the 120-day extension under 121C is that you provide notice in the way that the statute lays out. Here, Mrs. Garner provided provided notice as per statute, delivered notice to the appropriate individuals, and relied on the 120-day extension granted by 121C to provide her or to produce her lawsuit.
Well, at the
but-
time that,
Yes, ma'am.
at the time you filed suit, the claim against the agent had been extinguished by operation of law, and that the statute had run as to the agent. So if you take just the exact language out of Absher without considering the Healthcare Liability Act, it does seem to fit these facts. So where does the Healthcare Liability Act factor in here?
Well, there's a few things. Even if you take it on the face and Absher, the defendant hospital filed in their answer and response a comparative negligence claim, which would have allowed us, if we wanted to bring in the anesthesia provider, so it wasn't actually barred by operation of law because you had another 90 days.
Well, it was barred by operation of law for you to bring a direct action.
Right, but I
Correct.
could have brought a direct action after they provided a response and
Which they didn't
looked
do.
to comparative negligence within their claim. So that allowed me to once again go after the agent if we so chose to.
But you didn't.
But we didn't desire to do that. Correct, sir.
Well, the hospital says this is unfair.
Well, and the hospital also speaks to that they didn't have the opportunity and that notice is provided so that one can investigate the claim and can also look to their potential to settle the claim prior to litigation. They did not need to consult with a tortfeasor to do that. They could have gotten an expert opinion from an anesthesiologist and or looked at the anesthesia closed claim database to find what their liability was in this action. So their communication with the treating physician was not necessary for them to investigate the claim. And
Mr.
Were the
Glant?
anesthesia records in the record? Were they in the hospital
absolutely.
records?
I'm a board certified anesthesiologist as well. Anesthesia records are not part of the anesthesia group's records. They're part of the hospital records. So they absolutely had access to those records at the time. Yes, ma'am. Yes, Your Honor.
Let me ask about the fairness issue. I have a couple questions. If you're forced to give notice to parent agents whom you did not intend to sue, then they're going to go hire lawyers, complicate your lawsuit,
Absolutely.
end up with a lot of matters you don't intend to be involved in the lawsuit, correct?
Correct. Yes, sir.
So my other question is, if we apply Absher here, and you agree that you would lose this case, correct? If we only applied the common law without consideration of the Healthcare Liability Act.
Well, not necessarily, because again, they at the time that they filed their answer, they did quote for a comparative negligence, which would have allowed us to bring.
Well, let's
the
put,
anesthesia.
let's put comparative negligence aside. If we just follow Absher, then you lose the issue that's before the court, correct?
Yes, sir.
Okay. What provision of the Healthcare Liability Act can you point us to change the outcome of this case? That's what I'm not hearing.
Okay. The outcome of us losing the case, or the outcome that
No, change it from a loss to a win before this court. What provision of the Healthcare Liability Act could you point us to?
Well, again, 2926, 121 states how you are to give notice, and that once notice is given, that is the only prerequisite for the 120-day extension to the statute of limitations and or the statute of repose on the person that you're suing. Here, we only sued the hospital. We only gave notice to the hospital because that is the only tortfeasor we were looking to pursue.
But to Chief Justice Page's point, if if ABSHR, let's assume ABSHR applies.
Yes, sir.
That's the common law of this state, correct?
sir.
And there's basically a presumption that a statute does not abrogate common law unless it's explicit or clear, correct?
Yes.
So what about the Health Care Liability Act is clear that it's that provision is abrogating ABSHR? Because you could comply with both ABSHR and the Health Care Liability Act, could you not?
You could, but only if you shorten the statute of limitation, which the Health Care Liability Act expressly states the statute is not to do.
Or you provide notice to the agents.
Yes, or you provide notice to the agent.
But that would be compliance with both ABSHR and the Health Care Liability Act, correct?
But the Health Care Liability Act
Yes or no?
Yes, sir. But,
Okay.
but the Health Care Liability Act states specifically to give notice to the people you intend to sue. So not those who you don't necessarily intend to bring into litigation. And I think it's important to note that notice is not benign. Notice has its issues. When physicians get notice, there's an increase in malpractice premiums. There is damage to potentially their board record. There is potential loss of employment. So notice to providers that you don't wish to sue. I don't believe that the legislature meant to do that, and I think that there is a negative impact on providers when they get notice and they're not sued. You are asked about that in your malpractice insurance applications and with renewals, as well as when you're trying to get privileges at hospitals.
Is there a negative impact to plaintiffs to require them to give the pre-suit notice to agents even if they don't plan to
Absolutely.
sue them?
So there can be, because now you have, again, as was mentioned earlier, now you have another set of lawyers, potentially, and that you would potentially have to deal with, and it brings in it can potentially confuse the issue, and now you have two defendants versus one on the opposite side of the issue.
You can also, as a plaintiff, feel the need to basically give notice to everybody who touched your client in the hospital.
Absolutely.
Nurses, I mean, just everybody, and that's.
Absolutely.
And that's
it
what
was
happens
mentioned-
most of the time.
Most of the time, and which is an issue because, again, notice is not without its issues. When you're given notice of lawsuits, you do have to report that, and it can have negative impacts in other places.
If we were to carve out an exception to ABSHR, or just say the fourth limitation identified in ABSHR doesn't extend to this situation, I mean, what line would we draw? I guess, and how could we draw that line in a way that wouldn't require kind of an inquiry into the subjective intent of the plaintiff? You know, whether the plaintiff intended ever to bring claims against the agent.
Well, in their initial filing, if they have not given notice to the agent and they didn't include the agent in the lawsuit, it would appear to me that they had no plans or intentions on pursuing the agent.
Do you think unless, I guess, are you proposing that unless there is something in the record that would indicate to the contrary? I guess something in the record that would suggest that, you know, this is an encircling movement, and that this is kind of a way to get at the, you know, to get the principal when maybe the initial plans to sue the agent somehow fell through, that this fourth limitation shouldn't apply.
Well, in filing that initial lawsuit, it would be hard for me to imagine a situation other than you couldn't identify those defendants that an exception like that would apply. Which brings us also to 2926 121A5, which requires that you give notice of any additional potential defendants in the case, which again would allow you to bring those defendants in if necessary.
But again, how is that relevant here? Because you didn't. So the statute would run anyway at that point. I mean,
Absolutely. And the court
I guess I'm just having a hard time understanding how that's relevant for us in this case, since you didn't do it. If you'd done it, Okay, but you didn't do it.
We had no intention to do it, though,
Right.
in our case. So in our case, where you have no intention of suing the agent, I think the plain language statute should apply. It is not ambiguous.
The plain language then, again, it's the plain language does not, by its express terms, abrogate absure, does it?
The plain language of the healthcare liability
Yes.
statute. If taken for its plain language, at its plain language, then it allows you, well, it's in conflict with absure, absolutely, because because
How is it
allows
in
you-
conflict if you can comply with both of them?
In order to get the 120-day extension of C, then it's in conflict with absure.
Or is it just apples and oranges? Absure didn't even consider the Healthcare Liability Act. So
Ab-
I'm
absolutely.
having trouble reconciling the two when there's no common ground there. Absure just didn't deal with the Healthcare Liability Act.
And Justice Lee, you are correct in that, because absure was heavily weighted on the fact that the defendants in the fourth section or category there, Huber and Creech did not initially file vicarious liability claims, but only after the statutes of repose and or res judicata had barred them from doing so. Here, we are following the statutory language to file an initial claim of vicarious liability against the principal.
Is there any legal significance to the fact that this case involves a statute of limitations and not a statute of repose?
Yes, in the fact that, well, it also goes to the fact that you are, this is early in a lawsuit, where the statute of repose is 3 years. It seems as if you would, and as an absolute bar, in the statute of limitations, as the example I alluded to earlier, you could actually, with comparative negligence and such, still bring that agent in, where in the statute of repose that wouldn't necessarily be an option. So the harm that defense hospital claims about lack of being able to communicate, they made no attempt to communicate with anyone until after filing their answer 6 months later, and then getting the qualified order of protection. I don't see how they were prejudiced by not being able to speak to the treating physician, anesthesiologist. And as pointed out earlier, it wouldn't have made any difference in their negotiation if they had at that point. The statute itself, again, speaking of 121A1, clearly lays out the requirement for notice, and clearly lays out the fact that C lays out that that is the only requirement for the 120-day extension, as well as further in C that if through comparative negligence another party is named, the notice requirement is no longer required in bringing that person in. So you can amend your complaint as we had the opportunity to, but we were only going after the principal in this case.
It's not required for you to use all your time if you're,
Okay, that's it. Then I'm
okay. All right.
That's what you wanted to hear, wasn't it?
Thank you.
Your Honors, very briefly, I would just state that counsel for the appellee did acknowledge that the provisions of the Absher holding and this, the General Assembly's HCLA provisions for pre-suit notice can apply together, that they both can apply. And that's really what we say as well. We say that the Court of Appeals decision erred in coming to that conclusion, which was directly in conflict with a decision that they had just previously made in the Taylor versus Miriam's Promise case.
But in Taylor, though, there was a suit against the principal and the agent, and notice was improper, and they were trying to fix it, essentially, right? So that's different than this case.
I don't think it was materially different, Your Honor, in that in the Taylor case, the plaintiff sued, the plaintiff gave pre-suit notice to the hospital, did not give pre-suit notice. In that case, it was an actual employee, a social worker, and then there were motions to dismiss. The plaintiff, like here, attempted to use the 120-day extension of the statute of limitations as to the claims that were made, and then the trial court dismissed the case based on the fact that by operation of law, the claim against the agent was barred because there was no pre-suit notice to the social worker. And so, again, we say
It's not exactly what we have here, is it?
Well, I do think it is, because it is, you have the plaintiff in Taylor only got pre-suit notice as to the hospital, did not give pre-suit notice as to the employee, then attempted to use the 120-day extension for the claims as to the hospital and the employee, and the trial court ruled and the Court of Appeals affirmed, based on Absher, that the claim against the agent was barred by operation of law because there was no pre-suit notice given to the agent. And that's exactly what we have here.
Was the agent sued in the Taylor case?
Yes, the agent was sued, but
that's a difference, isn't it?
I don't think it changes anything materially as it relates to what we're talking about, which is that by operation of law, because the agent didn't receive pre-suit notice, the statute of limitations ran as to the agent when at the 1 year period, and then suit was later filed against the hospital and the agent. But it's immaterial that the agent was also sued, because the court's ruling, the trial court and the Court of Appeals rulings were based on Absher and the fact that the claims against the agent were barred by operation of law when the suit was filed, and therefore the claims could not proceed against the hospital. That's exactly on all fours with what happened in this case, even though in that case there was a claim. And so there was a lawsuit also filed against the social worker, the employee. But we would just say, just like Appellee's counsel acknowledged to Justice Bivens, that they can be applied together. And in this case, we don't think it was appropriate. We think the Court of Appeals erred by finding there was a conflict that required reversal. And Appellee's counsel also made the argument again that what took place here was a shortening of the statute of limitations, and there just absolutely was no shortening of the statute of limitations. The statute of limitations by law is 1 year, and under 121C, the plain language of that statute, it states it will not shorten the statute of limitations. It doesn't say anything about that there will automatically be an extension. There has to be a compliance with the whole framework. And it doesn't say there can't be an extension, and that's all there was not here. There was not. We're saying there wouldn't be an extension of the statute, but there is no shortening of the statute of limitations. I don't need to take up my last 30 seconds either, but I thank you very much for the opportunity to appear before you.
Thank you, counsel. Mr. Hiven, you may call the next case.
Dennis Harold Pulse versus HTI Memorial Hospital Corporation.